By way of introduction, I would like to say a little about myself. I am a Chartered Engineer and Fellow of Engineers Ireland. I am a Director of John T. Garrett and Associates Consulting Engineers and a member of Engineers Ireland Panel of Conciliators. I am a mediator trained by Mediation Forum Ireland, and I have a diploma in life and business coaching from the European Coaching Institute. I have given evidence in court cases and arbitrations over the last 35 years. Training of expert witnesses is included in the services provided by John T. Garrett and Associates. My presentation, The Engineer as an Expert Witness, was shortlisted by Engineers Ireland for an Excellence Award in 2016. I would like to point out at the outset that in this presentation I intend to share my knowledge and experience to the best of my ability. The presentation should not be considered a substitute for formal, in-depth training. Nothing in this presentation should be taken as case-specific legal or technical advice, and the opinions expressed are my own, based on experience. The title of today's presentation is The Key Role and Duties of the Expert Witness. And in my first slide, I have included 3 words which I consider crucial in the provision of quality expert services to the courts. And I emphasize the importance of being truthful, independent, and impartial. The aims of this presentation are to share what I have learned as an expert witness, to demonstrate in practice the engineer as an expert witness, and to heighten safety awareness. In the slides, I have included a number of cartoons. These were based on actual cases in which I was involved as an expert witness. I asked a local artist in Limerick, Frank Boucher, to prepare the cartoons from photographs so that I would protect the identity of the parties involved. The learning outcomes include that you will know the difference between evidence of fact and expert opinion evidence, that you will understand the role and duties of the expert witness, be able to prepare with confidence to act as an expert witness, and be more aware of how simple things can lead to accidents. In 2008, the Law Reform Commission published a consultation paper on expert evidence. In this, the Commission made provisional recommendations to ensure the continued benefits of having reliable expert evidence available to courts. The provisional recommendations included that the term expert should be defined. There should be detailed guidelines containing a list of factors which can be used to help the court assess the reliability of expert evidence, and that there should be formal guidance code for expert witnesses, which could be statutory or non-statutory. There should be a ban on any fee arrangements with expert witnesses which are conditional on the outcome of a case. Submissions were invited as to whether both parties should be required to exchange expert reports relating to all civil claims. There should be a set form and structure for expert reports. There were many more recommendations. With regard to witness testimony, there is a rule against opinion evidence. It is a long-standing rule of our law of evidence that, with certain exceptions, a witness may not express an opinion as to a fact in issue. It is for the tribunal of fact, judge or jury, as the case may be, to draw inferences of fact, form opinions and come to conclusions. You will note from my slides that where I have used quotations, I have given the references at the bottom of the slides. The main exception, however, is expert opinion evidence. An opinion may be given by a witness who has expertise in a particular area which is relevant to the issue at hand. The purpose of this is to provide the judge or jury with the necessary specialist criteria for testing the accuracy of their conclusions and enable them to form their own independent judgment by applying these criteria to the facts proven in evidence. Section 25(5) of the Civil Liability and Courts Act 2004 defines an expert as a person who has a special skill or expertise and who a. has been engaged by or on behalf of a plaintiff or defendant in a personal injuries action to give expert evidence in that action, or b. for the purposes of or in contemplation of a personal injuries action has been requested to carry out an examination or investigation in relation to any matter for which such special skill or expertise is necessary. Section 2 of the Act defines expert evidence as evidence of fact or opinion given by a person who would not be competent to give such evidence unless he or she had a special skill or expertise. What is an expert witness? There is an amount of judicial commentary on definition of expert witness. An expert may be defined as a person whose qualifications or expertise give an added authority to opinions or statements given or made by him within his area of expertise. There is legislative guidance on definition of an expert. Report or reports or statement from accountants, actuaries, architects, dentists, doctors, engineers, occupational therapists, psychologists, psychiatrists, scientists, or any other expert whatsoever intended to be called to give evidence in relation to an issue in the action. So, what are the necessary experience and qualifications? Therefore, whether the expertise stems entirely from practical experience or from formal study, or a mixture of the two, is irrelevant once the person can prove that they have acquired the knowledge that gives them an expertise not possessed by the ordinary person. What is the main role and function of the expert witness? It is to furnish the judge or jury with the necessary scientific criteria for testing the accuracy of their conclusions, so as to enable the judge or jury to form their own independent judgment by the application of these criteria to facts provided in evidence. However, there is more to it than that. The expert witness can help instructing party to decide whether there is a case, along with the strengths and weaknesses, prepare a report, help prepare the statement of claim or defence, advise on disclosure documents, advise the instructing solicitor and barrister on questions for the other party's expert, meet other experts and try to limit the issues, advise on settlement negotiations, the overriding duty is to the court. It should be firmly implanted into the expert's mind that his or her function is the provision of unbiased information to the court and not to provide a one-sided opinion preferred by the instructing party. Proving expertise. The party calling the expert bears the burden of proving the expert's qualifications and credentials as an expert in the field in question. This is normally done by way of preliminary questions during the examination-in-chief stage of the proceedings, after the witness has taken an oath. If there is a challenge to the witness's expertise, this can be proved by the expert by testifying about his qualifications and/or experience. In the absence of a rebuttal of expertise, the judge will accept the witness's testimony of his qualifications or experience as prima facie evidence of his expertise, and primary evidence of this will not be required. Now let's talk a little about expert reports. The Law Reform Commission recommends that there should be a set form and structure for expert reports. The report must be addressed to the court and not to the party or parties from whom instructions have been received. The expert's qualifications and experience should be outlined in detail and relevant certificates of proof attached. The terms and conditions of the appointment of the expert witness, including the payment arrangements, should be explained. All material instructions, oral and written, which were given to the expert and on the basis of which the report was written, must be outlined. If a potential conflict of interest arises, the facts relating to this should be stated. All relevant information relating to the issue, including that which is capable of detracting from the expert's opinion, should be outlined. All materials used by the expert in coming to the opinion clearly distinguishing between matters of fact and matters of opinion. Where tests or experiments have been conducted in the course of creating the report, all related information must be included, such as methodologies, results, and details about the individuals and qualifications of those involved in the carrying out of these tests. The expert should indicate if the opinion is provisional or conditional on certain factors, or if they believe they cannot give a formal opinion on the issue without further information, or where they believe they cannot make an opinion without qualification. A signed declaration that the contents of the report are true and that the expert understands the overriding duty owed to the court and that the report has been created in compliance with this. If, subsequent to the completion of a report, an expert changes his or her opinion on any material issue in the report, the expert witness must state this in a supplementary report. So in 2017, the Law Reform Commission published its report on the consolidation and reform of aspects of the law of evidence. There were key recommendations, which included that the recommendations be incorporated into an evidence bill, that an expert be defined as a person who appears to the court to possess the appropriate qualifications, skills, or experience about the matter to which the person's evidence relates, whether the evidence is of fact or of opinion, and who may be called upon by the court to give independent and unbiased testimony outside the knowledge and experience of the court. Provide for key duties of the expert witness. The Minister of Justice may publish codes of practice for expert witnesses. Expert witness to comply with code of practice. Expert witness has an overriding duty to the court to provide truthful, independent, and impartial evidence to the court, irrespective of any duty owed to the instructing party. The expert has a duty to state the facts and assumptions, and where relevant, any underlying scientific methodology on which his or her evidence is based, and to fully inform himself or herself of any and all surrounding facts, including those which could detract from his or her evidence and, where relevant, his or her expressed opinion. Confine evidence to matters within the scope of his or her expertise. State clearly when a matter falls outside the scope of his or her expertise. Distinguish between matters of fact and matters of opinion when giving his or her expert evidence, whether given orally or in the form of a written report. The expert has a duty to his or her instructing party to act with due care, skill, and diligence, including a duty to take reasonable care in the drafting of any written report. A prior professional or clinical relationship should not necessarily prevent a person from acting as an expert witness. A trial judge may rule inadmissible the evidence of any expert witness who fails to comply with any of the duties set out in the draft evidence bill. A solicitor instructing an expert witness who is not covered by indemnity insurance is under an obligation to make his or her client aware of the possible consequences of the failure to obtain such insurance. On the question of immunity, of an expert witness. The Commission recommends that, to the extent, if any, that the common law immunity of an expert witness from civil liability has survived, the draft evidence bill should provide that it is abolished and that it is replaced with civil liability of an expert witness limited to circumstances in which it is established that the expert has acted with gross negligence in giving his or her evidence, or in the preparation of an expert report in anticipation of civil or criminal proceedings. That is, falling far short of the standards of care expected of such an expert. I would take the opportunity to draw your attention to a case in the UK. Jones, the appellant, v. Caney, the respondent. And included in this slide is a link to the entire judgment. So now we come to the key role and duties of the expert witness. At some stage in your career, you may be required to give evidence in court as an expert witness. Does this scare you? I would invite you to reframe your thinking and see it as a tremendous compliment that you should be put in such a position of trust. Prepare. Be truthful, independent and unbiased. And dispose any notions that you are a hired gun. You are not an advocate. There are powerful questions an expert witness should ask himself or herself. What are the issues, claims, allegations which concern me? Do these represent what I see as the true issues? Am I comfortable that they are within my area of expertise? Have I studied all witness statements and documents disclosed to clarify and understand the facts? Have I surveyed and made all relevant factual observations of places, machines, buildings, accounts, etc.? Have I clearly identified all assumptions I shall rely on so that if I'm challenged, I can explain them and identify all my sources? What do I see as the points of my assumptions, observations and conclusions that may be challenged, and what are my answers to them? As an expert with a responsibility to inform the court, have I improperly omitted anything relevant? Have I prepared my report in simple language, using as few technical words as possible? Have I explained technical words where I have to use them? What really matters in most cases are the reasons given for the opinion. As a practical matter, a well-constructed expert's report containing opinion evidence sets out the opinion and the reasons for it. If the reasons stand up, the opinion does. If not, not. So, when you are asked to take instructions to act as an expert witness on a case, you should always ask yourself the question, am I a competent person to assist the judge, or jury in this case. Use proper equipment. A quality camera is a must. Always have appropriate personal protective equipment and ensure all measuring devices are accurately calibrated. Now we come to deal with cross-examination. And cross-examination is the questioning of a witness by the party who did not call them. The purpose is for your evidence to be tested. The other party's barrister may try to show that your information and opinions are inaccurate or unreliable, or try to elicit evidence that is helpful to their case. You should expect searching questions, attacks on your credibility as an expert, attacks on your expert opinion. You should remember this is an adversarial system. The cross-examining barrister is only doing his or her job. Some useful tips. Be friendly, warm and helpful. Maintain good eye contact with the judge. Listen to and understand the question. Stay calm. Direct your answer to the judge. See every question as an opportunity to put forward the strongest points in your evidence. The barrister has a toolbox. The barrister may try to get you to agree to absolutes, ask you to speak up, look at you with disbelief, silence, sarcasm. The barrister might interrupt you, may pretend to be confused, direct attack on your ability, or may pass notes to colleagues. The barrister might repeat earlier questions or pick up on typos in your report. Getting your name wrong, focusing on irrelevant points, running questions together, attacking your qualifications, comparing you to other experts. I would suggest that you avoid saying words like never or always. Visualization is a very powerful tool in preparing for a court case. Find someplace quiet, close your eyes, breathe deeply. Now imagine yourself in the witness box, sitting comfortably. Well prepared, you are in control. You have preempted every question and every challenge put to you in cross-examination. You have 3 or 4 well-researched reasons for every opinion. You are clear, polite and friendly. Firm when necessary. You have the judge's attention. He or she is enjoying learning from you. He or she respects your professionalism as an expert witness. He or she accepts what you say. You thank the judge and leave the witness box. Job well done. Before giving evidence in a court case, it is not unusual to feel nervous. But I would invite you to remember that your message to the court is more important than your nerves. If you focus on your message, you will get your own ego out of the way and focus on the job in hand. There's more to be aware of. Statutory Instrument 254 of 2016, Rules of the Superior Court's Conduct of Trials 2016, and Statutory Instrument number 255 of 2016, Rules of the Superior Court's Chancery and Non-Jury Actions, Pre-Trial Procedures 2016. These came into operation on the 1st of October 2016. They include provisions for the statement of claim to disclose intention to offer expert evidence and state the field of expertise and matters on which expert evidence is intended or proposed to be offered. And the same applies for the defendant, including the counterclaim. Both Statutory Instrument 254 and 255 should be read in full. The court may appoint an assessor, and the assessor shall take part, as the court may direct, prepare a report for the court on any matter at issue, attend trial and be available to assist the court. The court shall cause a copy of the report to be sent to each of the parties, and any party may use that report at the trial. Where an assessor provides advice or other information to the court shall inform the parties of such advice or information and afford each of them an opportunity to make submissions in respect of it. A judge may direct each party to identify the field of expertise required and, where practicable, the name of the proposed expert. Fix time or times for exchange of reports. Direct that evidence be given by a single joint expert. Select an expert from a list prepared or identified by the relevant parties, or direct that the expert be selected in such other manner as the court directs. Subject to certain rules and time limits, a party may put concise written questions concerning report to an expert instructed by another party or to a single appointed joint expert, and answers shall be treated as part of the expert's report. Experts can be required to meet privately and discuss their proposed evidence and prepare a joint report identifying such evidence as is agreed between them and such evidence as is not agreed. The trial judge may require opposing experts to be examined and cross-examined, or apply the debate among experts, then examination, cross-examination and re-examination if deemed necessary by the trial judge. In relation to Statutory Instrument 255 of 2016, a judge may order or give directions regarding exchange of documents or information, require a list of the persons expected to give evidence, require information on any matter of a scientific or technical nature which may be at issue or may be the subject of evidence, Require details of any arbitration or alternative dispute resolution process that may be available to the parties. Where the parties intend to rely on expert evidence, make an order that experts meet and prepare joint report. Require a booklet containing the expert's report on each side and any reports of any single joint expert. A book of exhibits appropriately numbered. Written report containing a summary of the evidence signed and dated by the expert. Supplemental report within specific time frame. I would consider it a very good idea for those that have not given evidence in court before to visit the courts and observe expert witnesses in action. Take the opportunity to assess the witness by asking the following questions. Was the expert witness appropriately dressed? Was he or she respectful when taking the oath or making the affirmation? Was he or she composed? Did he or she demonstrate good listening skills? Did he or she maintain good eye contact throughout? Were his or her responses to questions clear? Did he or she talk to the judge? Did he or she appear confident? Did he or she demonstrate a good attitude? Was it evident that he or she was well prepared? Did he or she use authentic references? Did he or she come across as being credible? Did he or she come across as being unbiased? Did he or she come across as being independent? Did he or she have an understanding of the issues? Had he or she the ability not to take things personally? Was it evident that he or she had preempted questions? Did he or she maintain control during cross-examination? Was he or she able to get his or her message across? Did he or she assist the court? In this slide, I have included useful references as follows: the Law Reform Commission consultation paper on expert evidence, the Law Reform Commission report on consolidation and reform of aspects of the law of evidence, Rules of the Superior Court's Conduct of Trials, Statutory Instrument 254 of 2016, Rules of the Superior Court's Chancery and non-jury actions and other designated proceedings, pre-trial procedures, Statutory Instrument 255 of 2016, and a very useful textbook is A Guide to Expert Witness Evidence by Tottenham M., Prendergast E.J., Joyce C. and Madden H. Never do, say or sign anything you are not comfortable with. And never forget that your integrity is not for sale at any price. Thank you for listening.